Well, good afternoon, everyone. Welcome to the National Sea Grant Law Center's webinar series. Today, we're going to be focusing on federal updates. So updating everyone on topics or issues that we've been tracking and covering in the previous webinars. And also, because we're a quarter into the year, we thought it might be nice to do a roundup of the advisory requests that the National Sea Grant Law Center has been working on for Sea Grant programs. We are recording the webinar and it will be shared on our website following the webinar. We are also trying something new today with the Zoom transcript or captioning. So it might not work right because we have a lot of technical terms and things, acronyms and things from our work, but we wanted to try to start doing that for accessibility, and we'll be experimenting with different options. And so with that, I'm going to go ahead and get started. So just a quick overview for those who are new. I'll do a brief introduction to the National Sea Grant Law Center. And then, as I mentioned, we'll be starting with updates on federal actions. And then the second half will be about our advisory requests. So quickly, for those who might be new to the webinar series or to Sea Grant, the National Sea Grant Law Center is one of 34 Sea Grant programs. We're based at the University of Mississippi School of Law. We were established to provide non-advocacy legal research, outreach, and education services to the Sea Grant Network. And so please visit our website. All of our research and information is available on our website. And also don't forget to follow us on Twitter and Facebook. That's the primary mechanism we're currently using to push out information about new blog posts, new products, things like that. Right. So update on federal actions. So there's no specific order for the topics that we're covering today. It will cover some legislation, regulations, orders, policies. So it's a bit of a grab bag of topics that we're doing today. And please feel free to ask questions at any time in the chat box. We may be able to answer them as we go, but we also will have time for Q&A at the end. And also, if at any time throughout the webinar you have a question or a topic that you're interested in that we're not covering, please share that in the chat as well, because we can cover that next month or reach out to you directly. So this might be something, I don't know how many people are following closely, but there has been this ongoing regulatory saga around genetically engineered animals that are intended for human food, so agricultural animals. Historically, the USDA and the FDA have shared jurisdiction over food, with the Food and Drug Administration regulating animal biotechnology and the USDA overseeing genetically engineered crops to protect them from plant pests or diseases. But the FDA's handling of the approval process for these type of animals has kind of been the industry has not been happy with that process because it's very slow, and it has so far only resulted in 2 animals making it through the process. One is the Aqua Bounty salmon, Aqua Advantage salmon, of interest to us, that has been approved for sale and is currently being grown in Illinois, I think Indiana. I can never quite remember. Indiana. Stuart says good. Thanks. And then most recently in December, the FDA approved it's called a GAL-safe pig. It's a pig that the meat has of a less allergic reaction for certain people that respond poorly to the proteins in pork. And so at the very end of the Trump administration, They released an MOU between the USDA and Health and Human Services Department to transfer oversight of these animals from the FDA to the USDA. It's important to note that it was controversial at the time, even in November, and the FDA is on the record of opposing this transfer, right? So it was happening at the departmental level above the FDA. And in December, USDA APHIS published a notice of rulemaking that they were going to move ahead to develop regulations to implement this transfer. That notice period closed in February, but pursuant to some of the executive orders the Biden administration issued related to reviewing regulations that had been issued or were in progress by the Trump administration, the USDA, oops, sorry for the typo, the USDA reopened the public comment period in March. And so that is open now until May 7th. And so the public can continue to submit comments with respect to this transfer of jurisdiction from the FDA to the USDA. So the FDA remains on the record opposed to this transfer. So we'll have to see how it might move forward under the new Biden administration and new agency officials at both the USDA and the FDA. And with that, I'll turn it over to Zach.
Thanks, Stephanie. I'm going to be talking a little bit about the Coronavirus Food Assistance Program, or CFAP, specifically the second incarnation of it, CFAP-2. Some of you who have been following these seminars or keeping an eye on this program from the beginning will remember that CFAP was originally created by the CARES Act last year, late March 2020, after the seriousness of the coronavirus, especially its impact on the economy, became clear. So that was CFAP-1, and later on, the program became extended just through regulatory action by the USDA in CFAP-2. There were some issues, there was some confusion with the original program around which aquaculture species were eligible. Luckily now they've greatly expanded and simplified this process. So all eligible aquaculture species would include species of aquatic organisms that are grown as food directly for human consumption, as well as any fish that are raised as feed for fish that are in turn consumed by humans. On top of that, any operations that grow ornamental fish that are propagated and reared in an aquatic medium are eligible. And this was a great point of confusion, especially with that original program. Molluscan shellfish and seaweed are both eligible for CFAP 2.0. So you have some pictures here of open water aquaculture, molluscan, seaweed aquaculture. There's a note here at the bottom, and I think that this drives the point home in terms of how wide the net is cast, that it really involves any species that's raised by a commercial operator in a controlled water environment. Whether it's on land, in water, fresh water, salt water, doesn't matter. The USDA, and more specifically the FSA, the agency responsible for this program, began accepting new and modified applications for CFAP-2 on April 5th, so that application period is already open, but FSA has not set a deadline yet for submissions. We don't know exactly how long we can expect this window to remain open, so if you know anybody who might be interested or eligible, they are already eligible to start submitting those applications. And if you have any more questions, any information, feel free to ask in the chat box or visit www.farmers.gov/CFAP2/aquaculture.
Great, thanks, Zach. Next up is Kathy.
Yeah, hi, good afternoon, everyone. So I just wanted to give a couple updates of where we are with the nationwide permits for mariculture. And so on our last time we talked about them, we talked about the ongoing litigation in Washington state over the 2017 nationwide permit 48 for shellfish. And so in that case, the federal district court had ruled that the nationwide permit 48, what the agency, the Corps had done was kind of illegal. So they said that the Corps' decision that the permit would have only a minimal environmental impact, was not supported by evidence, was arbitrary and capricious, and was not in accordance with either the National Environmental Policy Act or the Clean Water Act. And so the district court, vacated all the nationwide permits in the state of Washington. That case up until February was still ongoing. And so Taylor Shellfish and others, from the time that ruling came out in 2019 have, tried to challenge the ruling. And the last iteration of that happened just in February. So the Ninth Circuit heard oral arguments on February 2nd in the case. And so Taylor Shellfish and the other, organizations that were trying to challenge the ruling said that they wanted those, almost 900 permits in Washington to be reinstated. And they argued that the new nationwide permit that was just issued had not mooted the case. And in particular, because there would be kind of a lag time between when the new nationwide permit would be issued to the growers in the state. The Ninth Circuit rejected all of those arguments and affirmed the District Court of Washington's opinion that nationwide permit 48 violated both NEPA and the Clean Water Act. And they issued the decision pretty quickly, only in 9 days. So they seemed pretty firm in making that decision. So next slide, Steph. And so just an update on the 2021 nationwide permits that were issued. So just as a refresher, the court decided to issue a handful of modified and new nationwide permits, and the modified ones, including nationwide permit 48, was a little bit early. They issued them before the other permits were set to expire. And so we have 3 for mariculture. So we have the modified nationwide permit 48 for shellfish, and then 2 new mariculture permits. So 55 is new for seaweed and 56 is new for finfish. And so, Stephanie alluded to, when the Biden administration took office, they issued a lot of executive orders to kind of review regulatory actions that were taken kind of in the twilight of the Trump administration. The nationwide permit in particular, even the Trump administration gave it a 60-day effective date, so it built in the time for the Biden administration to review it. But, the Biden administration didn't take any action. So they became effective on March 15th. So just, less than a month ago. But questions remain about how these are going to be implemented or if they will. So nationwide permits is kind of a misnomer. And so the 30+ district offices of the Corps have the discretion about whether to adopt nationwide permits or to add conditions. And so we're kind of in a waiting period to see what those offices are going to do with the permits and if they'll even be implemented. And then the Center for Biological Diversity and other plaintiffs in February issued a 60-day notice of intent to sue to the Corps based on what they say are violations of the Endangered Species Act. They are arguing that the nationwide permits needed formal programmatic Section 7 consultation under the ESA, and that did not happen. And even in their letter, the CBD letter, states that, they're hopeful that the Biden administration would look at the permits and kind of fix these issues that they think they saw. So that doesn't happen. So I think it's a pretty good bet that, CBD is going to be following a lawsuit once they're able to from that 60-day notice. So we're just going to kind of have to sit tight still about how these new permits are going to be implemented. And we'll definitely keep you guys posted as we learn more on them.
And Kathy, one thing to note on that, so the 2017 permits, they're still in effect, right? These were issued early.
Yeah, so these 2021s were issued early. I think they weren't set to expire to 2022. So those, growers that have a 2017 nationwide permit, that's still in effect. So they're good to go until the new one gets adopted or rolled over and issued to them. And then my other update is on the Paycheck Protection Program. And so at the end of March, Congress passed and President Biden signed the Paycheck Protection Program Extension Act of 2021. And what it did was extend the deadline for PPP loan applications. So it was set to close on March 31st, and Congress decided to extend the application period till May 31st. And just an update again, so in the latest coronavirus legislation before the Extension Act, Congress created 2 separate types of loans that you can get under the PPP. So, businesses are still able to apply for their first PPP loan, but they created the second loan, which is called the second draw loan, for certain lenders to come back and get more money through the program. The PPP still has a good amount of money left in it from what Congress appropriated from this new round of legislation. And what's important that Congress also did was, previously it was kind of the application deadline and the SBA deadline were at the same time. And this new law has given the SBA a whole nother month to look at all the applications that kind of trickle in at the end of the application period. So if businesses, who, might be interested in the program, it's still open and there is definitely still money to get. The SBA PPP page has a lender match tool. So if a business isn't sure of what, lender to go through, so the PPP, they have to be matched with a lender instead of getting it directly from the SBA. And they also have good FAQs to kind of explain the process for the application. The other change that I just wanted to highlight is that the SBA decided to change the calculation of loans for sole proprietors, independent contractors, and self-employed individuals. And so now they're allowed to use their net profit instead of, so to kind of allow them, previously, it wasn't really letting those types of borrowers take into account their business expenses, and the new changes are now allowing them to kind of take those expenses into account to hopefully get them a little bit bigger loan under the program. But that's, I think, all I have for the PPP stuff.
Great. Thanks, Kathy. I think Olivia is up next.
Thanks. Yeah, I'll give a brief update on some national monuments. So in January, President Biden issued an executive order that was titled Protecting Public Health and the Environment and Restoring Science to Tackle the Climate Crisis. And this executive order required the Secretary of Interior and along with other coordinating agencies to review boundaries and conditions placed on national monuments during the Trump administration, and then make a recommendation to the president on whether any of these previous conditions or boundaries should be restored. Specifically, it was directing review to Bears Ears, Grand Staircase, and the Northeast Canyons and Seamounts Marine National Monument. So on March 17th, the Secretary of Interior announced that this recommendation would be delayed until after she met with stakeholders in person. And that meeting is scheduled for this week. I believe it's tomorrow, actually. So we are still waiting for those public recommendations to see if anything will change. Along with this, the Northeast Canyons Marine Monument has also had a series of ongoing litigation that has continued through this most recent executive order. So for some brief background on this marine monument, President Obama established it in 2016 under authority of the Antiquities Act. And this establishment was challenged in the DC District Court, and they argued that President Obama did not have the authority to establish the monument under the Antiquities Act. And the court ultimately found that the president did have authority to establish it And this was appealed to the appellate court, which agreed and affirmed the district court and found that the monument was properly established. So at the same time as this, former President Trump in June of 2020 issued a presidential proclamation, and this allowed for commercial fishing to resume within the monument borders. So after that proclamation, these fishermen groups and petitioners asked the Supreme Court to review the case and reverse the appellate court decision. And the environmental groups argued that this issue was moot because President Trump had already restored commercial fishing. So on March 22nd this year, the Supreme Court ultimately decided to decline review over the issue of how the monument was created. So this means that the appellate decision stands and the monument was properly created. And now we are waiting to see if the Secretary's report is going to recommend discontinuing commercial fishing or allowing it to continue in the monument borders. Next slide, please. Another update is to the DriftNet Modernization and Bycatch Reduction Act. So this bill was reintroduced in February this year. I think we talked about it in our January webinar, but the same bill was previously introduced and then approved by the House and Senate last year, but then vetoed by President Trump in December of 2020. So it has now been reintroduced. Some of the key provisions of the bill include a 5-year phase out of large mesh drift nets in federal waters. And the bill also authorizes NOAA to assist fishermen with switching to more sustainable types of gear. And it also has like a permit buyout program. There are a few exceptions. It doesn't apply to nets shorter than 2.5 kilometers or nets with mesh greater than 14 inches. So the bill has been referred to the Subcommittee on Waters, Oceans, and Wildlife. So we are waiting to see if there'll be any changes to the bill and whether it'll again be passed by the House and Senate. Thanks, next slide. One more update for the turtle excluder device rule. So going back a couple of years, in December of 2019, after conducting an environmental impact statement, NMFS issued a final rule on turtle excluder device requirements. And the rule has a number of requirements and modifications, but one of the controversial parts of the rule was that it exempted trawling vessels shorter than 40 feet from being required to use these TEDs. And so the rule was supposed to have taken effect on April 1st of this year, which was a pretty long period so that fishermen could adjust to these new regulations and implement the correct gear. But on March 31st, the agency delayed the effective date of the rule until August 1st of this summer. And the agency stated that this was because of COVID and they needed more time to conduct workshops on how to use these devices and making sure there was time for fishermen to transition gear. This rule was challenged yesterday on April 6th when the Center for Biological Diversity filed suit, and they are arguing that NMFS issued the final rule without giving notice that it was considering exempting certain vessels from the rule. And they also argued that the agency failed to rationalize the rule and take a hard look at the environmental impacts that could jeopardize these protected endangered turtle species. Thanks.
Thanks, Olivia. And there was a question in the chat, I think going back to the legislation, the DriftNet legislation. Does it mention other types of gear, like the alternative gear they would want fishermen to use?
Not that I know of in the rule, but I can double check. And I think that they're planning on doing a set of training workshops. So that might have information as well, but I can try and follow up on that.
Great, thanks. Great, and yeah, now Tara.
Hi, everyone. So I'm going to talk about some recent actions with regard to offshore wind energy. First of all, as we talked about on a previous webinar, in his first week in office, President Biden issued Executive Order 14008, tackling the climate crisis at home and abroad. And as part of that order, he set a goal of doubling offshore wind power in the US by 2030. And then recently, on March 29th, the Departments of Interior, Energy, Commerce, and Transportation announced some new leasing, funding, and goals to accelerate this development. And I'm just going to talk about some of the highlights that were in that announcement. First of all, BOEM, or the Bureau of Ocean Energy Management within the Department of Interior, announced a new priority wind energy area in the New York Bight. That's an area of shallow coastal waters between Long Island and the New Jersey coast. You can see that on the map there. BOEM will now prepare an environmental assessment to consider any potential environmental consequences of offshore wind development there. There is a public comment period that's open now until April 28th. If you'd like to make any comments on that, you can go to regulations.gov and look up the docket number BOEM-2021-0021. And then after that, the next step will be a lease sale. Well, not the next step, but eventually there will be a lease sale in late 2021 or early 2022. And then BOEM also announced it would prepare an environmental impact statement for the Ocean Wind project in waters near New Jersey. The announcement also highlighted that $230 million would be available for port infrastructure related projects. The DOE's Loan Programs Office announced it would facilitate access to $3 billion in funding for project developers through its Title 17 Innovative Energy Loan Guarantee Program. And then the National Offshore Wind Research and Development Consortium announced the award of $8 million to 15 offshore wind research and development projects that were selected through a competitive process. And then finally, as part of that announcement and of note to Sea Grant, NOAA's Northeast Sea Grant Consortium, in partnership with DOE, DOC, and NOAA's Northeast Fishery Science Center, issued a request for research proposals to support $1 million in grant funding for understanding offshore renewable energy. The funding competition is accepting pre-proposals from eligible Northeast researchers May 14th, and that information is available on MIT Sea Grant's webpage. So on the next slide, I'm going to talk a little bit about Vineyard Wind. This is slated to be the first commercial offshore wind project in the US. It's an 800 megawatt wind energy project offshore of Massachusetts. It's had years of regulatory review and public comment, but finally in March 2021, BOEM completed its final environmental impact statement. This signals that the project will likely be permitted. It's not the total final action, but it's likely to happen and will probably go online by 2023. That's all of the update I have for that.
Great. Thanks, everyone. So yeah. So with that as our, and I'm sure there are federal actions that we've missed, right? There is a lot going on in the transition. The Biden administration is off to a running start. So we will continue to track and provide updates to these activities. And so with that, we wanted to, at the end of each quarter, to provide some information about advisory requests that the National Sea Grant Law Center has completed or is working on. And we wanted to start doing this one to maybe raise the visibility of this service a little bit for folks that might be new to the Sea Grant program and don't know how it works. But we also think that the research might be of interest to programs outside the programs that ask the question. And so this is a way to also highlight what is available. So just a quick reminder, The advisory service is a legal research service that the National Sea Grant Law Center provides for free of charge to Sea Grant programs. So we are prohibited from providing legal advice. So we can't, say this is what you should do. This is research only. For that reason, we also don't work directly with members of the individual public or members of private organizations. They can send their requests through Sea Grant programs, and we work to generalize those questions, but this is a service really provided to Sea Grant programs. And then there are opportunities for federal agencies, stakeholders like NOAA, Fish and Wildlife Service, to tap into this as well, kind of as secondary stakeholders or users of the service. So if you have a legal question, we encourage you to reach out to us, send me an email, send an email to any member of the National Sea Grant Law Center team, and we'll work with you to get those answers. And so the rest of the webinar, we're just going to talk a little bit about research questions that we've received, the work that we've done. All of this information, unless it's still in progress, is available on the National Sea Grant Law Center's advisory request page. It's archived by subject matter, but we can also try to link as we go through to where the memos are as well. So, okay. So first up is Kathy.
Yeah, so this is a question that came to us from Indiana, Illinois Sea Grant, especially Amy Schambach, who I think is on the webinar today. But it had to do with some fish losses that they experienced in Illinois this year due to severe winter weather. And so fish farmers in Illinois were growing largemouth bass. They had a massive fish loss. And so they applied to the USDA for ELAP funding to try to save their farm. So ELAP is the Emergency Assistance for Livestock, Honeybees, and Farm-to-Raise Fish program. And it's supposed to be a source of funds to help growers who aren't covered by other USDA programs. So if you don't have crop insurance, if you're not enrolled in the non-insured disaster assistance program, which is another program that's supposed to, help those who don't have crop insurance. So kind of like a, not, I wouldn't want to say last resort, but, if you don't have other coverage that protects you, you can go to ELAP. And so when the farmers in Illinois went to their county farm service agency, the directors there responded that bass raised of food fish aren't covered by the ELAP program because ELAP only covers losses to bait fish and game fish and not fish that's raised as food. So Amy came to us and asked us, would ELAP be able to cover the losses for largemouth bass? And so we went and did some research for her and created a research memo. And so it's on our webpage if you go in the aquaculture section. And what we found was that in 2014, the FSA and USDA did make a change to the program. And so previously it was limited to only bait and game fish, but the new regulations were written in a way that would allow the deputy administrator to add additional aquatic species to the ELAP program. And aquatic species is defined to include fish that are used for food. But unfortunately, as of 2020, the FSA ELAP handbook doesn't reflect that any additional species have been added. So that discretion, formally had not been exercised to expand ELAP to cover fish for food. And so we had some, recommendations for the farmers. And we said, you could go to FSA when you go back and talk to them and ask whether additional species had been added since the updates in 2020. And then if not, ask if there was a process to petition for additional species to be added. And so Amy, kept us posted on kind of what happened. And so when the farmers went back to the county offices. They had a good conversation about, maybe getting these additional species added. But ultimately, when their claims kind of went to DC for approval, they were denied based on kind of other reasons. So they said that the farmers didn't, operate the farms in a way that would have prevented the losses. So that's kind of where we were. So we're, hoping that eventually maybe expand it. But at this point in time, it's looking like it's just going to stay a game fish and bait fish for now.
Thanks, Kathy.
Oops. Hey, I'm next. So I'm going to talk about a request that we got from Texas Sea Grant about a Weighmaster program, training program that they are thinking of implementing. They had heard that sometimes the Weighmaster's decisions are challenged in court, and so they were just questioning what their liability might be if they are providing the training. We just provided a short memo that kind of discussed a few things they could consider. We talked about vicarious liability, which is when a supervisory party, like an employee, liable for the conduct of a subordinate. In this instance, it wouldn't really apply because the Weightmasters wouldn't be employed by Texas Sea Grant, and Texas Sea Grant isn't running the tournament. We talked about negligence, what the standard for that is, and if they provided reasonable care and providing the training, that they would be okay. And then we talked a little bit about immunity from liability. The state of Texas is immune from suit unless it's consented to be sued, and they have extended that to its subdivisions, which includes universities. So it was a short memo, and they may have some follow-up questions, but that was what we covered there.
Great. Thanks, Tara. On to Olivia.
Thanks. We also received an advisory request for research on the Texas shrimp fleet. So we were approached by a graduate research student at the Hart Research Institute and referred to us via Texas Sea Grant. And this student was conducting her dissertation on how communities have been affected by shrimp fishery policies. And she is analyzing the evolution of policies that have guided shrimp fishermen and impacted the community. So she requested advisory assistance from us to build a timeline of major management changes within the Texas shrimp fishery and compile source documents for her to analyze. And so we ended up providing 3 products to her. We found the documents and compiled them into a Google Drive. We also provided a summary of all the relevant statutes, regulations, and some case law. And we also made a graphic illustrating the timeline of these major statutes and regulations. And that's shown on the slide there. For the research, we broke it down into Texas state law and then federal law. And for each, we found the relevant cases and regulations. Overall, I'd say it was a really interesting project. On the state law side, we ended up finding cases as old as like 1906. And we discussed some of the bills establishing the early Office of Fish and Oyster Commission and later Texas Shrimp Conservation Act. And then on the federal side, we summarized the Magnuson-Stevens Act, the Endangered Species Act, as well as management plans for the red snapper and turtle excluder device regulations, because those also impacted the shrimp fishermen. Thanks.
Thanks, Olivia. And just for full disclosure, this research is not available yet on our website because it is going, so the student is analyzing it for her dissertation. And so once the dissertation is published, she'll be including some of this information, and then that's when it will we'll share it more widely. But if anyone's interested, I'm sure we can share pieces of it and give you more information kind of offline. And finally, our last request we wanted to share, Zach's going to handle.
Thanks, Stephanie. Right, so this last advisory service request deals with the spread of aquatic invasive species, specifically quagga and zebra mussels, via interstate boat sales. This request came to us off the back of the work that the Law Center has already done on building a consensus among Western states to regulate water decontamination, specifically to prevent the spread of aquatic invasive species and quagga and zebra mussels in particular. Why this issue keeps coming up and how it ended up on our desks once again is because Montana has recently been catching a very high number of watercraft infested with quagga and zebra mussels at inspection stations. And what they found is that many of these vessels are originally coming from Great Lakes states and making their way to Montana, thanks to transactions that are facilitated by online marketplaces like Facebook Marketplace or Craigslist. One of the issues that creeps up just sort of straight out the gate is that these Great Lakes states have had mussel infestations dating back to the late 80s or early 90s, whereas Montana, despite a scare in 2016, is still officially quagga and zebra mussel free. So Wisconsin Sea Grant is working with Montana to figure out what can be done, and they submitted an advisory request to the Law Center to help out. How we fit into the picture is we're analyzing the current legal framework to determine how we can leverage liability under the current laws to incentivize compliance among people involved in transactions that lead to boats being hauled westward, specifically towards Montana. This project looks at 4 states in particular, just as a model or a microcosm: Wisconsin, Minnesota, North Dakota, and Montana, which you see highlighted on the slide. It's a very popular corridor for hauling commercial hauling watercraft from the Great Lakes to Montana. We looked at state laws in all of these states, as well as federal laws that would be violated when quagga and zebra mussels are transported on vessels westward. We looked at the legal responsibility of parties involved: buyer, seller, hauler, marketplace, brokers. And then we considered both legal and non-legal measures that can be taken to improve compliance. And that was one of the things that I really liked about this project, is that it wasn't all intensive legal work. Some of the non-legal avenues that we suggested included quagga, zebra mussels, aquatic invasive species, water decontamination, and employing training manuals, professional code of ethics, including materials about these issues at trade shows, putting out PSAs about mussels and aquatic invasive species. And even the legal suggestions that we were putting out there wasn't necessarily creating new laws. A lot of what we were talking about dealt with the authorities they could go to, like the ANS task force, or the use of more fundamental laws like contract law in order to spread awareness and apportion liability from the beginning, say through marina leases. This is another advisory request that we haven't quite wrapped up yet, so all of the materials aren't available on our website quite yet, but we are wrapping this up, and I expect that anybody who's interested can check out that on our website quite soon. Thanks, Stephanie.
Great. Thanks, Zach. So that's it. That's our, I guess, another whirlwind tour through the world of the National Sea Grant Law Center. So we are happy to take, any questions that you may have. Feel free to put them in the chat box. We also have a small group today, so if you want to come off of mute, you can also do that as well. I just want to thank everyone again for participating. We hope you find these webinars useful. We are open to any and all feedback in the chat or by email if you want to keep the message more private, to how we can improve or make it more useful to you and your programs. And Kathy just posted another SBA update in the chat box.
Yeah, they just announced it. during the webinar. So.
Okay. Well, if we don't have any questions, then I will just tell everyone thank you again. I hope everyone has a great rest of the day, and stay tuned. And I hope you join us for our next webinar at the beginning of May. Thank you.